Hello everyone, this is Tom Fox. I'm the Compliance Evangelist, and I'd like to welcome you to June's podcast series on 1 month to better investigations and internal reportings. So what do you do when the call, the email, or the personal tip comes into your office where an employee reports suspicious activity somewhere literally across the globe? That activity might well turn into a Foreign Corrupt Practices Act issue for your company. In today's climate, it can turn into issues under lots of different anti-corruption jurisdictions. The Brazilian Clean Companies Act, the UK Bribery Act, or even domestic anti-corruption laws, such as brought GSK to bear in China. As the Chief Compliance Officer, it will be up to you to begin the process, which will determine, in many instances, how your company will respond going forward and will set the tone throughout this most difficult period. This month's podcast series will provide to you all the steps you need to consider going forward. I want to take a look at independent versus in-house investigations, investigation protocols, the different resources that a compliance practitioner may bring to bear in an investigation, such as internal audit, IT, and legal. And I'll take a look at special issues such as privilege, Upjohn and Miranda warnings, data privacy, and of course, the Yates memo and its effect. I think you will learn a lot this month if you follow this podcast series. This is Tom Fox. Thank you very much for listening to the June podcast series. Day 10, 10 best practices in a cross-border investigation. In an article in the FCPA report by Mara Sin and Michelle Albert entitled Internal Investigations, How to Conduct an Anti-Corruption Investigation, Developing and Implementing the Investigation Plan, they laid out 10 best practices in a cross-border investigation, and I want to review these with you today. Number 1, offer interview translations. Most people know English to a certain extent in the international business community, and it's a very universal language nowadays. However, if you want to get into detailed questions in an interview, a non-native English speaker may assume they understand everything. You may think they understand everything, but they probably don't. This means it's important to have someone present in the interview who speaks the witness's native language, and you can't assume that it's going to be otherwise. You should make clear to the witness that if there's no problem with English, a translator may not be needed, but the reality is you're probably going to need a translator. Number 2, avoid cultural pitfalls. Yes, there really are cultural pitfalls, and these can lead you to digging very deep holes for yourself that you need to get yourself out of. It starts with things like dress, but it also goes to things like decorum. You need to fully understand what the cultural mores of the country you're in during the investigation This will certainly facilitate your investigation. If it's in certain countries, you can't remove things from desks. If you want to do document review, obviously there are going to be laws around this in certain places as well. You do not want witnesses to begin the interview process with a negative view of you, and you want them to be cooperative. This really makes it in your best interest to follow local cultural norms. Otherwise, the interviews can become incredibly embarrassing and awkward at times. So do not fall into cultural pitfalls. Number 3, observe data privacy restrictions. Hopefully by now, most American lawyers are well aware of the different privacy restrictions and requirements in countries governed by the EU and the U.S., and probably now the United Kingdom. Some of that's related to employee and employment law, ownership of certain information, and other parts of the law that really do not have to deal with data privacy but are more personal information. You must have a data privacy expert. If you talk to Jonathan Armstrong, he will detail for you multiple cases where companies illegally obtained documents and they could not be used in an investigation. In fact, there's a very famous trial that collapsed for the Serious Fraud Office where the information forming the basis of the criminal prosecution was uncovered in an internal investigation led by U.S. counsel who did not follow UK law. So You need to understand the data privacy rules. You need to have a data privacy expert assisting you. Number 4, comply with labor requirements. Related to the data privacy is similar to longstanding Weingarten rights of unionized employees to have representatives present for interviews. There are many countries outside the U.S. where works councils or other similar organizations are responsible for the interactions between employers and employees. Moreover, employees have both statutory or labor code rights based on their status, whether or not they're a member of a labor union. These rights can actually drill down into the types of questions you can ask or even prevent you from meeting or interviewing employees. So you may need to work through a works council. You may need to have pre-approval to the works council. You may have to allow an employee to have a representative present. But you need to have a local in-country labor law expert who can advise you on these matters. Number 5, yet be aware of other local requirements. So it's incumbent that you work with local counsel in the country where you're performing the investigation to garner an understanding of the witness's rights. Many lawyers think doing an investigation can certainly be problematic, and the document reviews, the works council, and other issues should lead you to utilizing a local lawyer to help you. If you're working with a large U.S. multinational firm, you may be able to get that in one firm, but you may need to seek local counsel. 6, put forms in native translations. This is related to the earlier point on offering interview translations or translation services doing interviews. So if you're going to put documents in front of a witness, make sure they're in the witness's local language so that the employee will understand these. Certainly this is going to be critical if you put a consent form in front of someone to sign, consenting to an interview. If you do not have it in local language, it may be deemed to not be an informed consent. And if you do not have informed consent, as all lawyers know, that consent can well turn out to be void. Number 7, preserve the attorney-client privilege. In a brief review, the attorney-client privilege is a communication between an attorney and client for the purpose of seeking legal advice. The reason the client has a privilege is to make sure they are not afraid to go to their lawyer and disclose full facts and information. The purpose of the privilege is set up so that you will be encouraged to have the protected conversation with counsel and make sure you understand the law so you can follow it. The U.S. rule is relatively straightforward. It applies to both in-house and outside counsel. The issue you're going to have is that it's quite different in the EU, where there's no absolute privilege for in-house counsel, and unfortunately this has now been extended to the United Kingdom. So you need to have someone who can advise you on what's the privilege situation. If you utilize in-house counsel from a foreign subsidiary in the EU or the United Kingdom, you may lose the privilege. Number 8. Prepare for local enforcement actions. Most American lawyers are aware that we've seen other countries begin to engage in global anti-corruption enforcement, from GlaxoSmithKline in China to Brazil to the United Kingdom to Denmark. A wide variety of companies have engaged in anti-corruption enforcement. This means that information that one government knows, whichever government that happens to be, you should expect and assume that multiple governments will know about that same information. This makes it more likely there could be some sort of local enforcement action against your client when you're investigating a matter around a potential anti-bribery, anti-corruption claim. This is yet another instance where local counsel can be helpful, as that they should be aware of the different enforcement agencies in the different countries and how those enforcement agencies have ways of doing things. For instance, in some countries such as China, they like to perform pre-dawn raids, where they essentially come, get people, and they're asleep, and they're waking up, and they arrest them and seize the documents. Yet in other countries, it would be extremely unlikely to happen. So once again, your local counsel would be able to give you an idea. Some enforcement agencies would like you to make an appointment and come by, but it's really that local knowledge is something that you need to consider. Number 9, prepare for security risks. This is really personal security, physical security, and health safety. You may be going into situations of countries, particularly in Africa, that are war-torn. Consider also the Ebola outbreak in Western Africa. If you're conducting an investigation in ravaged areas, you may not want to send your employees to Liberia or Libya to interview these people. A better plan might be to remove the people you are interviewing and bring them to you or a local hub outside the impacted area. This avoids a whole host of issues, as you do not want to pay for extra security, and frankly, you don't want to be walking around with someone with a loaded machine gun next to you. And finally, number 10, protect whistleblowers. This is an incredibly important matter, both inside the United States and outside. And I've talked about this really throughout this podcast series. But you have to protect the whistleblower. There's a split right now of whether people outside the United States can receive whistleblower status, but I think the better practice would be to protect them, and certainly the U.S. Supreme Court will be taking a look at this. Certainly the SEC has announced they will pay whistleblowers outside the U.S. who come forward and meet the requirements of a Dodd-Frank bounty up to 30% of the penalty. But the practical reality is this means even if courts determine the Dodd-Frank provisions do not apply for retaliation for foreign nationals, the SEC can still honor the communication and compensate the whistleblower. So these best practices around cross-border investigations are excellent points for you to review and consider. If you retain outside counsel to lead your investigation, this would be a very good format or a series of questions for them to follow as well. So what are the 3 key takeaways from today? Well, first of all, it should be clear that translations into native language or local language are going to be critical. This means translations in interviews. This means translations of key documents. This means if you have a consent form to consent to be interviewed, it needs to be in the local language. Number 2, never forget to utilize your local counsel. This can be utilized in a wide variety and for a wide variety of reasons, certainly to help facilitate the interviews, but also to navigate the often critical and treacherous waters of a local anti-corruption investigation if local regulators are involved. And number 3, never, 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 never retaliate. And the Dodd-Frank Act, SEC has made clear that they're going to pay whistleblowers who are outside the United States, even if they don't receive protection. So this is Tom Fox. Thank you very much for joining me, and I hope you'll join me tomorrow for another day of 1 month to better investigations and reporting. Hello, everyone. This is Tom Fox again. I'd like to thank you for listening to today's episode. If you have listened to this podcast on iTunes, I would greatly appreciate it if you would rate our podcast, as it would help in our rankings and help get the word out about the only 1 month series focusing on specific aspects of a best practice compliance program. If you have any questions, please feel free to contact me at tfox